Okay, guys, we are going to now be discussing Chapter 7 material. This is antitrust law. To me, this is probably the biggest portion of the exam, at least in terms of the per se rule of reason, after the idea behind the personal intentional tort like assault, battery, false imprisonment, invasion of privacy, defamation, stuff like that. Okay, I'm going to break this video up probably, or this chapter up into probably 3 segments. The first segment will be one that is just dealing with the general idea behind antitrust law, talk about the Clayton Act, the Sherman Act, maybe the FTC Act a little bit, get all the first few pages of the study guide. The next 2 parts that I'll probably break it up into are the areas of antitrust. And if you I don't think you've gone to class. I think it's all on video now for Chapter 7. So SWIM makes a log chart or asks you to make a log chart in class. We are going to modify that log chart, make our own to help you understand the per se rule of reason. So as we get started, and one other person asked me about all the videos. I'm not doing any of the questions because usually the questions at the beginning of this test round are just to gauge how everything's, how people interact and how they're doing. I look at their faces and see what's if they look puzzled or something like that, or they're having difficulty with a certain area, so I can spend more time on that area. I don't get any of that feedback with these non-live videos. So we're not going to do the questions at the very beginning. I would suggest doing them before a hit pause. Try to do those 10 questions at the beginning of the green packet here and see how you do before you listen to the videos. That would be my suggestion. You have the answers on the answer key already. All right. What we're going to do is we're going to get started. We're in the green packet. Now, your green packet might look like this with the answer key already attached to the front copy. They made two sets of copies, and one they left the answer key on it for some reason. A lot of y'all will just have the initial page at the very beginning on it as well. So either way, it's in chronological order. It just has an extra sheet attached to it. The other thing that you're going to have is you're going to have your light green sheet. Regardless if there's an answer key already on there, I think I gave everybody a light green answer key. So you might have this answer key twice. But on the back is a chart that we make on in the class on the dry erase board, usually when we do it live. I'm going to explain this when we get to probably parts 2 and parts 3 of the video and how I'm going to run this. But I've already made the log sheet out for you to look at real quick. We're going to put terms, case names, areas of antitrust law into this chart and explain it. That'll be in part 2 and part 3's video as well. Okay. We're going to have to make one chart, and I will explain how the chart works during this part 1 video, and then we'll talk about the part 2 videos and part 3 videos with the 2 charts that are already in your green packet. All right, let's go ahead and get started. Let me adjust the screen just a second. Now I need y'all to see the completely near bald head, not have it cut off. Anyway, okay, on page 201 of the study guide, we start with chapter 7. The first page didn't have really much that we need to worry about. You can read over it briefly. I really don't discuss this first page very much on antitrust law. We usually start with the material on page 202 of the study guide with Adam Smith. Adam Smith was an economist in the 1700s, late 1700s, who felt that government should not really be involved that much. He had a book called Wealth of Nations, and basically one of his economic premises in that idea is that the market will correct itself without government intervention, okay? The market will correct itself. You don't need the government to get involved. Well, we've noticed with this coronavirus that the government has to get involved in some way or the market won't correct itself. We see runs on grocery stores and stuff like that. Well, in this case, we're talking about antitrust law. And basically what the government has really decided in antitrust law is they need to get involved. So they go against Adam Smith's Wealth of Nations, his invisible hand theory. Now, this invisible hand theory, the old professor before SWIM really kind of pushed on this a little bit. You have maybe 1 or 2 questions. SWIM maybe has one about who was Adam Smith, how does his idea affect and deal with antitrust law? Well, his theory was you wouldn't need antitrust law, the market would correct itself. Well, the problem is the marketplace is going to have people that are going to do anything they can or will do anything they can to try to get a leg up on other competitors. And sometimes you're going to do things that are outside the boundary of ethics and social responsibility. And sometimes you're going to do things that are going to be right above board. And you're just going to have a better product. And that's why people are going to buy your product. Regardless of the good or bad reasons or intentions, you're going to have market not correct itself without government involvement. Thus, we have antitrust law. Now, SWIM, when they rewrote Chapter 7, SWIM got a little upset because a few of his cases were taken out of the study guide. And these are cases that he talks about in class. He'll probably talk about on the video now that you have a video. He talks about them, and they are on the exam, and they are fair game on the exam. There's about 6 of them that have been taken out that he still has, as I call, a Tier 1 or a Tier 2. And if you're in the green packet, you should have a page that says antitrust law and just some basic general discussion of antitrust law. It's 2 pages. Okay, we're going to discuss a little bit of this in this part 1 video. Then after that, you have 2 pages of cases. Okay, case log sheet like we did for exam 1 for 2 pages. We're going to tier those cases, Tier 1s, Tier 2s, and Tier 3s. And if you didn't come for exam 1, a Tier 1 is, this is almost every single semester someone gets it on their exam. Now, with these being online exams, he may only have 1 or 2 forms versus the 6 or 7 that he normally does sometimes. So when I say Tier 1, I'm talking about the past. It doesn't mean that you're going to have it on this exam. Tier 2 is, it's not as frequent as the Tier 1s, but it's in his test bank. He's had a question over it. Therefore, we're going to discuss this material. And then Tier 3, never heard about it. I tell people when we log all these on our log sheet, when we have a little left-hand column that has a T for tiers, I tell people not to Tier 3s and just don't write anything because your eyes will naturally gravitate and you don't need to worry about the 3s, or at least you don't have to worry too much about the 3s. You want to look them over, great, but like I said, I usually, whenever I find out one's been moved from a 3 to a 2, we discuss it more in depth, and I haven't heard about that recently. Okay. Why I'm saying this now, even though we're going to get into case law more in parts 2 and part 3 of the videos, is because there's about 4 or 5 cases, maybe even 6 cases, that have been taken out of the study guide that he has on the exam and that you need to know. The first one would have been right here on page 202 of the study guide, right before what is anti-competitive. And the case is Kraft versus McConaughey. So if you have your case list, okay, if you have the case list, it's the very first one, all right? Kraft versus McConaughey, I even wrote the year, 1875. And that's going to be important for a little test question, multiple choice answer you need to know as well. You usually don't need to know the years of all those. This to me is a Tier 1 case. So if you want to put Tier 1 right there, you can go ahead and do so. In Kraft versus McConaughey, there were 4 grain merchants in Illinois. The 4 grain merchants agreed to conspire to fix prices. Now, this is an example of horizontal price fixing, which we'll get into much more in detail in the part 2, part 3 videos. But horizontal price fixing is where competitors to fix the price. Well, one of the grain merchants died, and the son took over the business, and he refused to enforce that contract with the other 3 grain merchants, saying, hey, he could lower his prices and get much more business and sell by quantity and make a profit even if he lowers his price a little bit. The other 3 grain merchants sued and said, no, you can't do that, and said this is a breach of contract. We had a contract for this, this price. It went all the way to the Illinois Supreme Court. Okay, it did not go through the U.S. court system. It went up to the Illinois Supreme Court. And the Illinois Supreme Court decided that it was an illegal restraint of trade. Now, we'll get into illegal restraints of trade a little bit later on, but it was an illegal restraint of trade, and they refused to enforce the agreement. And they said issues like this are not going to be justifiable, not going to be illegal. Now, what was the significance of this Kraft versus McConaughey case? Well, one, Kraft versus McConaughey was an example of horizontal price fixing. That's what you need to know. It happened in 1875, and this is 15 years prior to any statutory law we have on the books dealing with this idea of antitrust law. So the other thing that you need to know about Kraft versus McConaughey was, one, it was found to be illegal to breach, and a breach of contract didn't occur because the courts refused to enforce that agreement of contract. but also it established antitrust common law, and this is probably the most important point. It established antitrust common law before antitrust statutory law was created. So we had common law created before statutory law in 1875, and the area of antitrust was horizontal price fixing. Now, we'll go over some questions with horizontal price fixing, and you'll need to know that case as well. Another case that would have been right here is Brunswick versus Pueblo-Willamette, and it is a tier 2, although recently I haven't heard about it being on the exam, and I think it's because he kind of skips over it. I'm just going to talk about it briefly, and it would have been right at the middle of page 202 of your study guide had it been in there. I'm looking at the old study guide and comparing it to the new one and filling in the cases where they would have been. In Brunswick versus Pueblo-Willamette, Pueblo-Willamette had a bowling alley that was being run. One of its competitors was about to go out of business, and at the last minute, Brunswick decided, as a bowling manufacturer of bowling parts and equipment and supplies and stuff like that, they would keep the business open. Not only would they be able to sell more supplies because that business would need it, but they would enter into the bowling alley market, not just supply side. And it was more along the lines to say that have some more clients as well. Well, here's the thing. If you think about it like with A+, 4.0 and Go, Tutor John, if one of those was to go out of business, then the other two would have increased sales. Think about it. If one of the big 3 tutoring businesses goes out of business, the students are going to naturally gravitate towards the other 2. So therefore, there will be a spike in sales pickup if one of them goes out of business. And that's what Pueblo-Willamette was thinking. If this bowling alley goes out of business, my revenue will spike up. Well, with Brunswick keeping it open, Pueblo-Willamette sued and said, whoa, 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 you cost me future sales. Well, the thing is, when we talk about antitrust law, we're more worried about deliberately harming competition, not keeping competition levels the same or even increasing competition, which is good. But when you deliberately use actions or to harm your competitors, then that's when antitrust law comes into play. Well, Pueblo-Willamette thought the idea was, hey, we're going to increase revenue. Brunswick stopped us from doing so, so we're going to sue them for an antitrust violation. Well, the courts disagreed and said Brunswick did not do anything wrong. Their actions kept competition levels the same, maybe even increased competition levels, which is always good for consumers. Therefore, this action was not a deliberate harm by someone against another competitor. Therefore, it doesn't fall under antitrust law. So the big thing that you need to know about Brunswick is certain actions that do not deliberately harm competition don't fall under antitrust law. Those may be actually good for consumers. All right. If you look on page 202, when it talks about what is anti-competitive, extreme efforts to beat the competition only works when activities lead to better products, more efficiency, and better means rather than means justifying the ends. Now, let's talk about this briefly for a test question. When we get into the per se and rule of reason in part 2 and part 3, one of the fundamental things that you need to know is, are we going to allow an action to occur in a given situation based upon the facts and circumstances? Or are we going to automatically assume it's not going to be legal? Well, if a situation makes for better products, or it makes for more efficiency within the marketplace, i.e., a business can be more efficient in how it creates products, thus it can maybe lower the prices, which is good for consumers, or if a better product is made, that's good for consumers, or it increases competition, and that's good for consumers. All of those are good things for a consumer. And if they are good things for a consumer, we're likely going to want that to happen. We're not going to say automatically illegal. So think about this way. If an action could increase competition levels, it could increase and make better products, it could make more efficiently a business to make products, thus it could reduce cost on their products and maybe pass that on to consumers. All of those are good things. If they're good things, we are likely going to allow them. Okay, but at least if we allow or disallow, we're going to at least look at the facts and circumstances. And that's what rule of reason is all about. We'll get into per se and rule of reason probably at the very end of part 1 material in terms of the video. All right, on page 202 and 203, there's some sports examples. So if you're a sports-oriented person, you can look those over. Analogies are pretty decent. They don't really apply to antitrust, but they are some decent analogies. Okay, so as we've got this, what we have from page 202 is Adam Smith felt that government did not get involved, the market would correct itself. In areas of antitrust law, that doesn't work. The government has to get involved, and we create antitrust law. At first, it was created through common law, judge-made law with Kraft versus McConaughey. Then 15 years later, we're going to have the Sherman Act. We'll talk about that a little bit later on. And remember, anything that is deliberately going to harm competition probably falls under antitrust violations, but anything that's going to help competition, make for better products, more efficiency within the marketplace is likely going to be allowed. Therefore, if it's going to be allowed, we're going to look at it on a case-by-case basis and figure it out. All right. On page 203, we have our next case. The next case is Standard Oil New Jersey versus the United States. And this is Rockefeller's case. And Standard Oil New Jersey would be the third case in your little packet. You're going to put a tier 1 there. And if you want to put in parentheses right below the case name, you can go ahead and put Rockefeller case because you'll use those interchangeably on the exam. All right. This case was established in 1911. At the time, Standard Oil, Rockefeller's business, had about 90% of the oil market. Okay. And when that happens, you don't have the ability for people to enter into the marketplace and really compete against someone who has a virtual monopoly. So what the courts did, they found the action of Standard Oil to be completely a monopoly and went ahead and broke it up into smaller competing companies. Those like Standard Oil of California is now called Chevron. ExxonMobil is Standard Oil of New Jersey and stuff like that. So you have a bunch of them that come into play that are now when they were broken up. Now, would it be better for consumers to have one company that has 90% of the oil market and can dictate prices basically as a virtually monopoly, or to have 9 or 10 other smaller competing businesses along with the others, and they all compete against one another? And the idea was, let's break them up into smaller competing companies, and therefore they're going to compete against one another. Prices will drop. That's good for consumers. So the remedy that was used in Standard Oil New Jersey versus the U.S. was to break up the company that had created monopoly into smaller competing companies. So note that is an equitable remedy that was utilized by the courts in this case. Now, when we talk about this, we got to talk about this in conjunction with the Sherman Act a little bit later on. But remember that for the tier 1 Standard Oil New Jersey case versus U.S. On this case, you need to understand the one big thing. One, it established the idea of making a monopoly going to be illegal because it's going to harm consumers. It established the idea of being able to break it up into smaller competing companies. But more importantly, the Standard Oil New Jersey case versus the United States, Rockefeller's case, created the rule of reason principle that we're going to go much more in depth in part 2 and part 3 under antitrust law. So this rule of reason principle, which we'll discuss maybe at the very end of part 1, is now influenced or created by this common law case of Rockefeller, New Jersey, Standard Oil New Jersey versus U.S. All right. We have the Railroad Trust, Interstate Commerce Act, the ICC, used to regulate railroads. That was that Chapter 6 material. We're once again emphasizing a little bit there. On page 204, 205, 206, 207, the next 3 or 4 pages talks about the Sherman Act and the Clayton Act. So what we're going to do is y'all are going to fill out a 2-column chart. Well, actually, it's going to be a 3-column. One column is going to be the reasons or whatever we're doing. And then we're going to differentiate between the Sherman Act and the Clayton Act. Okay? So if you want to put together a column chart, we're basically comparing and contrasting the Sherman Act and the Clayton Act. Okay? There's also the FTC Act, but we're not going to worry about that in terms of the chart. Okay? The first thing we're going to have is, so you should have a 3-column chart. The 3-column chart should be what are on the far left should be what we're discussing, each row. Then the second column should be Sherman. The third column should be Clayton. All right. The first one is going to be, we're going to talk about Sherman. What year was it enacted? The year was 1890. Okay. The year was 1890. And it has 2 basic sections. One is section 1 dealing with illegal restraints of trade. And section 2 is monopolies. So if you want to, that is going to be on the bottom of page 204 and 205 dealing with these 2 sections. Section 1 of the Sherman Act deals with restraints of trade. So Section 1 deals with illegal restraints of trade. That's every contract, combination, contract, conspiracy in the form of trust or otherwise to restrain trade or reduce competition with foreign nations and as several states is guilty of a felony. So if you look at it in the bottom of 204, it says every contract, combination in the form of trust or otherwise, or conspiracy to restrain trade or commerce among the several states or with foreign nations is declared to be illegal. Kind of using that terminology that we have for the Commerce Clause on Exam 1. Okay, so what does a contract, a combination, or conspiracy have in common? Other than starting with the letter C, what do these three things have in common? In order for a contract, a combination, or conspiracy to occur, you need two or more parties. At least two, maybe more, but at least two. So a Section 1 violation, an illegal restraint trade under Sherman, will have two or more parties involved. Now, whether the government only goes after one party or goes after them all is irrelevant. You may have a case where it's only one party that they go after, but at least it requires two or more parties. Okay? Section 2 violations, and this is on the bottom of page 205, deal in Sherman Act that deal with monopolies. Section 2 deals with monopolies. Every person who shall monopolize or attempt to monopolize or combine or conspire to attempt to monopolize to restrain trade and restrain trade or monopolize any part of trade or commerce within the several states or with foreign nations shall be guilty of felony as well. So we're using, once again, the Commerce Clause terminology and using it again for now Section 2 dealing with monopolies. Now, when you have scenarios, and this is going to be more part 2, part 3, if it's an illegal restrained trade, combination, or contract, you need to know that's a Section 1 violation of Sherman for a possible multiple choice answer. If it is an attempt to monopolize, then that is likely going to be a Section 2 violation of Sherman that you need to know as well. All right. The other things that you need to know about Sherman. So we have the year of 1890. We have the two sections, illegal restraints of trade and monopolies. If you want to skip a couple of lines in your little chart, you can, because we're going to have 4 sections of Clayton. So if you want to make it to where the log sheet comes equal, you're going to need 4 lines for Clayton, 2 lines for Sherman. Sherman was Section 1 and Section 2. After that, what court do we go to? For Sherman, you go to a criminal court. Sherman, you go to it's criminal. So you're going to involve yourselves in criminal court. And because of that, you're going to use that Exam 1 material where it's beyond a reasonable doubt. You can get a court-appointed attorney if you cannot afford one. Fifth Amendment self-incrimination doctrine if it's an individual, not a business. All those things come into play. All right? The other thing for Sherman is what action does it have? For Sherman, the action is punitive after the fact, meaning we are going to catch you doing the action. Now, we'll talk about the difference between that and Clayton when we talk about Clayton in the chart as well a little bit later. The next one, the next row is punishment. A punishment for Sherman is going to be jail time or fines and jail time. It can be up to 5 years in prison and or up to $300,000. Now, I haven't heard about the numbers being a big thing on this exam, but when you get to fines and jail time for other exams later on down the road, they are a possibility. And with him making questions up maybe every year, fines and jail times for the Sherman Act is up to 5 years for a violation, Section 1 or Section 2, and up to $300K in terms of a fine associated to it. So fines and jail, 5 years, and or, so it could be an A and B but not C, C and A but not B type question, $300,000. We talked about guilt. Guilt would be beyond a reasonable doubt. And the administrative agency in charge of Sherman would be the DOJ. The DOJ. That is a dependent executive administrative agency going back to Chapter 6 material. We'll talk about that a little bit later on after we go through Clayton as well. The primary reason we have Sherman is because of Rockefeller. Okay, the Standard Oil situation was the primary reason why Sherman Act was created. Now, one other thing that you need to know, and you put it right under the reason why, the last column that we're probably going to have is Sherman applies to goods and services. Goods and services. Okay? Clayton is only going to apply to goods, but we'll get to that a little bit later on. So for the Sherman Act, here are the things that you need to know. Once again, It established the year 1890. It has Section 1 violations for illegal restraints of trade, Section 2 violations for attempts to monopolize. The court system is going to be basically criminal court, and the actions are going to be punitive after the fact. Punishment could be jail or fines up to 5 years and $300,000 in fines. Guilt would be beyond a reasonable doubt because it's a criminal case. The administrative agency is a DOJ, Department of Justice Antitrust Division, which is an executive or dependent administrative agency going back to Chapter 6. So that would be an executive dependent administrative agency that is economy-wide that deals with antitrust regulations across all different industries. And the primary reason we had it was to stop Rockefeller's Standard Oil and do with what we could about Standard Oil. It applies to products and services. So you need to have all that in your chart on Sherman. Now we're going to compare that and contrast it to Clayton. Clayton Act would be on page 206, bottom of page 206, and it goes through about the next 3 or 4 pages, although some of those pages are redundant. So we're going to skip over them and go back to them in the areas of antitrust law, i.e. towards the end, probably part 3 of the video. All right, the Clayton Act. The Clayton Act was enacted in 1914. So we had it in 1914. It has 4 sections that are going to be important. There's many more than 4, but 4 sections are going to be potentially multiple choice answers on the exam. Okay? The first one is Section 2. Section 2 deals with price discrimination. Whenever different consumers have to pay different prices with no logical reason, that would be price discrimination. That is a Section 2 violation of Clayton. Section 3 violations are exclusionary practices. This could include tie-in arrangements. This could include exclusive dealing contracts. This could include boycotts, whether vertical or horizontal. All of these are exclusionary practices and would fall under Clayton's Section 3. Section 7 deals with mergers, whether it be a horizontal, vertical, market extension, either geographic or product, or conglomerate type mergers. Mergers fall under Section 7 of the Clayton Act. Now, the last section is really not one that we discuss in class or on videos, but when you have an A, B, C, and D, this makes it for a perfect section because it is in the study guide, although it's not going to be a big one, but in case you get a storyline scenario. And that is Section 8. So we're skipping all the numbers besides 2, 3, 7, and 8, okay? Interlocking directorates is Section 8. And that means that you can't be on the board of competing companies. If I'm a CEO or if I'm the chairman of the board or on the board of directors for Nike, and as a CEO, I can't then also be on the board of directors for, say, Adidas, because they compete against one another, and it wouldn't be right for me to be on the board of one and also be on the board of its competitor. So if, say, Barney is on the board for Nike and Adidas, that would be a Section 8 violation of Clayton with interlocking directorates. I think this is the only time that it's going to be on the in the class is right there when we're talking about Section 8 violations and what they are under Clayton. But in case that is a multiple choice answer, you need to know what it is so you don't get confused. And there may be a storyline scenario saying, what would this be? And it would be a Section 8 violation if it occurred. All right. Under the court system, whereas Sherman was criminal, it is civil for Clayton. Clayton is civil. The actions are going to be restrictive or preventative. We're trying to stop it from happening beforehand. So think about it this way. Clayton would be much more preventative, restrictive, whereas Sherman would be much more punitive after the fact. It's kind of like, and I make the analogy usually, it's kind of like someone taking away your car keys because you're drunk. Now, if you just let them get behind the wheel and even drive a few feet, the police officer can pull you over for drunk driving. They're going to punish them after the fact, punitive after the fact. That's much more Sherman. You did it, you're busted, we nail you, fines, jail time associated to it because that's what Sherman does. Clayton would be much more, let's stop this action from happening before it causes any problems. Therefore, what they would do is likely take away your car keys because you're too drunk to drive. That would be more what is in line for the Clayton. Restrict, prevent it from happening. Okay? In terms of punishment, where we have fines and jail times for Sherman, we have probably legal and or equitable remedies under Clayton. Legal and equitable remedies under Clayton. Guilt for Sherman was reasonable doubt. Clayton is civil, so it's a preponderance of the evidence. Preponderance of the evidence. The administrative agency that deals with Clayton primarily is the FTC. Now, the FTC, the Federal Trade Commission, is in charge not only mainly of the Clayton Act, but also there's an FTC Act that we're going to talk about briefly in a little while as well. But the FTC was created in 1914. It is an independent, because it ends with commission, an independent, economy-wide administrative agency created in the historical era, going back to Chapter 6, that deals with antitrust violations, as well as false advertising claims. So when you're in 211, you might have that. In addition to false advertising, FTC deals with antitrust violations. Clayton deals with antitrust violations, and the FTC does. Now, Clayton also is under the jurisdiction in some parts for the DOJ, but it has no criminal in Clayton. So if the DOJ is in charge of it, it's also in charge of civil stuff. Now, Sherman has a slight part of civil, but for the most part, here's what you need to know, okay? This is, generally speaking, no absolutes. If it is Sherman, it is always, this is one of you, always going to be under jurisdiction of the DOJ. Sherman is exclusively the DOJ, okay? It's mainly almost all criminal. It does have some slight issues with civils. If you want to put that under Sherman, some civil, but not very much. Clayton is all civil, okay, has no criminal, and it's generally under the FTC. So if it's a civil action, it's likely going to be under the FTC, but it does have some DOJ. So Clayton can be also under the DOJ as well, but it would be civil as well there, because this Clayton Act has all civil and no criminal. Okay, so the DOJ can do both criminal and civil, and theoretically can do both acts, whereas the FTC can only do civil and only do the Clayton Act. Okay, and the only one that's criminal is Sherman. All right. The reason why Clayton was created was to fill gaps in Sherman that Sherman didn't either get to, or fill gaps due to public resentment associated to the act, okay, of Sherman. The courts are very lenient in Sherman, and they didn't want to fill in the gaps, and therefore Clayton tried to fill in those gaps with more restrictive preventative means. The last little thing that we had is, remember, Clayton only deals with products, not services. So if he gives you a storyline scenario, we're talking about in parts 2 and part 3, when we're talking about certain areas of antitrust. If he gives you a scenario and it's a service-based rather than a product or goods-based, you know it's got to be under Sherman rather than Clayton, because Clayton doesn't do anything with services, only goods. All right, that is going to include page 206, page 207 of your study guide, because we will come back to all the mergers. Mergers start on page 208. So basically all of 208, all of 209 is mergers. We're going to come back to this later on in the study guide, so it's kind of redundant. So we'll talk about it then when we talk about the areas of antitrust law. On the very bottom of 209 is that interlocking directorates. That's probably the only time you're going to see it there as well. Now on the top of page 210 of your study guide, we have the FTC Act. This is another act that you need to know. You're going to have about 5 acts in Chapter 7. You're going to have the Sherman and the Clayton being the primary 2 ones. Then you're going to have the FTC Act and how it relates to antitrust law. You're going to have a Hart-Scott-Rodino Act later on, and you're going to have the Robinson-Packman Act as well. So you have about 5 acts that you need to know. The main 2 that we've already gone over. The FTC Act on page 210, basically the section 5 says unfair methods of competition or unfair deceptive acts or practices that affect commerce fall under a section 5 violation of the FTC. Now this could be false advertising when it comes to chapter 11, when you have your chapter 11 exam on exam 3, chapter 11 are read only. So you need to know that as well. But section 5 of the FTC Act is really a catch-all for any unfair practices. So if you have an unfair practice when it comes to antitrust, it could also fall under the FTC Act of 1914. Because of that, the FTC's agency is empowered to investigate and enforce also antitrust law, not only under Clayton, but also it could be because of an unfair method of competition, unfair or deceptive practice could fall under Section 5 of the FTC Act of 1914. Now, why is that important? In case that is there, you may have that be a multiple choice answer that you need to go with as well. And the FTC Act is on the exam. It is probably an answer that could be there. Just understand what it does. Sherman and Clayton are the big two, but FTC would also deal with antitrust law in regards to it's a catch-all law for enforcement of antitrust law. And FTC being the independent economy-wide administrative agency in charge of antitrust law, whether it be with the FTC Act or the Clayton Act. All right. We've talked about the penalties when we made our chart right there. We talked about the civil and all that stuff right there. Remember, Sherman is mainly going to be money, but it does have some equitable remedies of an injunction or something like that as well. All right. The last thing before we get into the areas of antitrust law is this idea behind per se and rule of reason. Okay, let me talk about per se rule of reason, and then when we get into the areas of antitrust law on the next two videos, we're going to fill out the back of your answer key with this chart. Okay, but right now we're going to talk about the very top of this chart briefly about what it entails before we get into it for each individual area of antitrust law. This chart, if you're one of those ones that likes flowcharts, and the flowcharts worked on exam 1 for, say, valid, void, voidable, unenforceable, the drunks, minors, and sanes, when we did all that set up with all the terms, if that helped you, this will be one that would probably tremendously help you as well. We'll fill it in as we go. All right, per se and rule of reason. Per se says it does not matter why an action occurred. Cause, facts and circumstances caused to the court system is irrelevant. There is no defense to their action. It is automatically illegal. So if you look at this little chart before we fill in the bottom part, we'll fill in parts 1 and 2. But if you look, the way I have it set up is antitrust at the very top, and I say cause and facts. Do we really care about cause and facts? And the answer is no, or they're irrelevant. Then we go the way of per se. Per se is automatically illegal. Now, anything that's a case that was automatically illegal, or any area of antitrust law that's going to be automatically illegal, or any term that's automatically illegal, we're going to put in this little column right here so you can do a memorization. So, if facts and circumstances do not matter, if cause is irrelevant to the decision making by the courts, and the action is automatically illegal, it goes to the left of that chart and it's per se, or automatically illegal. If cause does matter, if cause and facts and circumstances are relevant to the courts, then that is going to be what we call rule of reason. Now remember, rule of reason was set up and created through the court case Standard Oil New Jersey, the Rockefeller case, Standard Oil New Jersey versus US. Rule of reason was established. And rule of reason says there could be ultimately many different factors that decide whether or not something should be legal or illegal. And here's the thing, and we talked about this in exam 1, and we talked about it when we talked about express versus implied. And I said, if you think an express contract is written and an implied contract is oral, then you're going to miss a bunch of questions on the exam dealing with storyline scenarios and questions on express versus implied in fact. I said express is language-based, implied in fact was action-based. Same basic idea here. If you think everything that's illegal is per se and everything that is legal is rule of reason, you're going to miss maybe a few questions on the exam. The first part was right. If it is per se, it's automatically illegal. We don't care about cause, or facts and circumstances doesn't matter. So that part was correct. But if it's rule of reason, it simply means we are going to look at facts and circumstances and then make a decision on whether it's legal or illegal. And if you'll notice in that chart on the back of your answer key, it has rule of reason and says you can go illegal one way or legal the other way on that flow chart. Now, I left a little middle column because we're going to be able to put certain areas that, are not specifically legal or illegal. We're going to put some areas in the middle there, and then we might put arrows going one way or the other depending on an action. And I'll talk about this a little bit later on, okay? But rule of reason simply means we look at facts and circumstances. And once we look at facts and circumstances, certain actions could be illegal, certain actions could be legal. But if they are illegal, they're not necessarily per se illegal, they're just illegal, which is an important point for exam question scenario. He may ask you, which of the following actions is per se illegal? And he'll give you some maybe case names or something like that. You know, the other question, Form B, may say which of the following actions were deemed illegal. Didn't matter if whether it is per se illegal or rule of reason illegal, it was just illegal. So then if you're talking about question number 1, which I said, which of the following are per se illegal, it would be all the cases in this side right here. If it says which of the following were illegal actions, then it would be everything on per se and everything in this column right here under rule of reason is illegal as well. So you have the option to where, you know, depending on the way the question's phrased, you have extra answers. All right. Before we get started, the next pages that you're going to have, you're basically going to be able to use 3 pages in your green packet for the next 2 parts that we go over. I think everything else is going to be in these 3 pages. It is going to be the 2 pages on cases. Right now, we've just finished Standard Oil New Jersey. We will be starting with Trenton Potteries when we get to the areas of antitrust law. So we've done the first 3 cases. And then after those two pages of cases, front and back, is a log sheet. Okay, and the log sheet has about 12 different areas of antitrust, and we're going to fill it out whether it's per se or rule of reason, and then you're going to fill out that chart. Those 3 charts are going to be the primary main emphasis of Chapter 7. You're going to have some little bitties things, and you're going to have that chart on Sherman Clayton and all the things that we just went over. But for the most part, the areas of antitrust law are going to be big. So we're going to be filling out this sheet, and I don't know if you can see it because my video is kind of green, but the sheet with a log of all the different areas of antitrust law when we do videos 2 and 3 on Chapter 7. All right, return shortly.